Turning next to factors increasing seriousness identified in the guidelines, I need to have regard to the fact that you were a heavy smoker and that there was extensive use of candles or tea lights for added light in the home. As such, it might be thought that the risks of fire in a house where the living spaces actually used were very cramped and where there was discarded rubbish around the home were significant. You were the mother of 4 boys, and there is an element of abuse of a position of trust. Your children were particularly vulnerable due to their age, and it is clear that the last moments of their young lives would have been with some acute physical suffering as the fire took hold and they sought to get away from it. It is also the case that others were put at risk of harm, including those neighbours and firefighters who attended. I cannot ignore your actions after the event in providing the account that there was a babysitter looking after the children. Not only did that result in another entry into the building with further risk to the firefighters, but it also led to extensive police inquiry as to their whereabouts. In setting out these factors, I need to be careful not to double count for those factors that impact on the initial assessment as to culpability. On factors reducing seriousness or reflecting personal mitigation, you have no previous convictions and have expressed remorse. It is clear that you will have to live with the knowledge that you bear responsibility for the deaths of your 4 children. I note a lack of premeditation and the impact of your current medical and mental health, as well as your personal background and circumstances. I have already referred to the reports on your mental health that form part of the evidence at trial. I've considered the guidelines on sentencing offenders with mental disorders. In doing so and applying the guidelines, I should make an initial assessment as to culpability in accordance with the offence-specific guidelines, and then consider whether culpability was reduced by reason of the impairment or disorder. As the guidelines provide, culpability will only be reduced if there is a sufficient connection between any impairment or disorder and the offending behaviour. In making that assessment, I've reflected on the impact of those reports as to the likely position in 2021 and the more recent reports. Reports post-conviction deal with your current medical and mental health position. The current position is somewhat different to the position back at the time of the fire and the deaths. It is very likely to be the case that serving any sentence imposed in the light of your eyesight and mental health issues will make that harder on you than on others, and I have sought to incorporate those matters in assessing the factors reducing the seriousness of the offence. In my judgment, to some extent, the factors increasing seriousness and those reducing seriousness balance each other out. However, in the light of all the submissions made, I reduced the sentence to one of 10 years custody. As I've noted in the course of submissions this morning, you do not have the mitigation of a guilty plea. Whilst this conviction requires me to consider dangerousness, and some of the reports I've referred to address the risks going forward, I do not find the test to be met here. Turning to sentence, on each of counts 1 to 4, there will be concurrent sentences of 10 years imprisonment. You will serve 2/3 of that sentence in custody. If your case is referred to the parole board, you may then be eligible for release at that point and will be entitled to release at the end of the custodial term. You have been on a qualifying curfew for 114 days, and so 57 days will count towards the sentence imposed. As the statutory surcharge applies, the appropriate order may be drawn up. I have asked my clerk to prepare a file of all the medical and mental health reports that I have seen, and that file will accompany you to prison along with a copy of these sentencing remarks.